Good afternoon, friends. Important video coming from Patna High Court, and that judgment in the case of Biswanath Traders is being upheld by Honorable Supreme Court on time limit to file appeal before first appellate authority. Time limit as prescribed under section 107 of CGST Act is 3 months plus 1 month for the condonation where reasonable cause exists. Now, in this particular case, which was before Honorable Patna High Court in the case of Biswanath Traders, what happened? Order in original was passed on 12th of March 2022. 12 मार्च 2022 को ऑर्डर इन ओरिजिनल पास कर दिया गया, जो इम्प्यून्ड ऑर्डर था अगेंस्ट एसएससी था. And this SSC was supposed to file appeal within 3 months time period. But what happened? They have filed the appeal on 8th of August 2022. Order was passed on 12th March. First appeal was filed on 8th of August 2022. The first appellate authority has rejected the appeal on ground of limitation, and first appellate authority has considered Honorable Supreme Court suo motu order number 3/2022, and whereby it was stated that a specific period is going to be excluded for calculation of limitation period, and this specific period was from 15th March 2020 to 20th February 2022. यानी अगर कोई भी पीरियड जो एक्सपायर हो रहा है या एक्सपायर हो गया बिकॉज ऑफ कोविड-19, ऑनरेबल सुप्रीम कोर्ट ने एक सुओ मोटो ऑर्डर पास किया था कि अगर आप कोई अपील फाइल कर रहे हैं और वो अपील आपकी इस पीरियड 15 मार्च 2020 से लेके 28 फरवरी 2022 के पीरियड में अगर एक्सपायर करती है, तो पहले तो हम इस पीरियड को एक्सक्लूड कर देंगे और आपको एक स्पेशल विंडो वुड बी गिवन टू यू फॉर 90 days to be calculated from 1st March 2022. Special window. So this order, which was passed on 12th March 2022, expired in that impugned time period which is being relieved by Honorable Supreme Court. So 90 days specific period to be calculated from 1st March 2022, which was expiring on 29th May 2022. यानी अगर ऑनरेबल सुप्रीम कोर्ट का जो सुओ मोटो ऑर्डर था, इसके हिसाब से अगर 90 डेज का टाइम पीरियड दे दिया जाए, तो 12 मार्च 2022 को जो ऑर्डर पास हुआ इम्प्यून्ड ऑर्डर, उसकी अपील फाइल हो जानी चाहिए थी 29 मई 2022 को, 29th May 2022. But this SSC has filed appeal on 8th of August 2022. Beyond 2 months and 19 days delay was there. First appellate authority has rejected the appeal on period of limitation, that it was not filed within due time period. So what happened? This petitioner has filed a writ petition before Honorable Patna High Court, and Patna High Court has held, and what is being said, listen very carefully, that since this SSC was not diligent enough not diligent enough to exhaust alternative remedy by way of filing first appeal within the time period prescribed, which is 3 months, plus 1 month, which is for the condonation period, as per section 107. So he was not diligent enough, यानी उसने within time limit appeal को file नहीं किया, and thereby Honorable Patna High Court find no reason that this petitioner should be allowed to invoke extraordinary jurisdiction under Article 226 to the Constitution of India. They do not find any reason and dismiss the writ petition. Then SLP was filed before Honorable Supreme Court, and Supreme Court has upheld जो जजमेंट पटना हाई कोर्ट ने पास की थी उसी को सुप्रीम कोर्ट ने बरकरार रखा. Uphold the judgment of Patna High Court, and the judgment of Patna High Court was, they do not find any reason that this petitioner could have invoked extraordinary jurisdiction under Article 226 to the Constitution of India. Second, he was not diligent enough to use alternative remedy which was available to him even after giving the relief of suo motu Honorable Supreme Court order number 3/2022. Now, they have not filed appeal within the time period, they were not diligent, and they have delayed the process. Even after considering Supreme Court suo motu order, there was a delay of 2 months and 19 days. Hence, whatever Honorable Patna High Court has ruled and concluded, that is being upheld by Honorable Supreme Court. So what is the takeaway from this video? First, we have to look at the time limit as prescribed in the GST law. GST law is a specific law. You cannot argue that the Limitation Act 1963 is giving you some wide time period. Please. And there are judgment now which is saying that if specific time limit exists in GST law, that need to be abide by. यानी जो GST law में है वो आपको फॉलो करना पड़ेगा. अगर आपके पास ऑल्टरनेटिव रेमेडी है तो आपको उस ऑल्टरनेटिव रेमेडी को यूज कर लेना था, एग्जॉस्ट कर लेना था. This petitioner should have filed the appeal within the time as prescribed under section 107 of CGST Act. He was not diligent enough. Even the benefit of suo motu order of Supreme Court was also extended, even though there was delay of 2 months and 19 days. So first, we have to be careful about the time limit as prescribed in the GST law. If we are not filing a reply or appeal within the time-bound manner as prescribed in the GST law, there is a possibility that you will get contrary order against you, even though you are having good case on merit. यानी मेरिट के ऊपर आपका अच्छा केस होगा, लेकिन अगर आपने विद इन टाइम रिप्लाई नहीं किया और अपील फाइल नहीं की तो पीरियड ऑफ लिमिटेशन पे आपके सारे ग्राउंड खत्म हो जाएंगे, इवन दो मेरिट के ऊपर आपका अच्छा केस है. सो बी केयरफुल फर्स्ट ऑफ ऑल. सेकंड, आई एम फाइंडिंग लॉट मेनी कॉन्ट्ररी जजमेंट, divergent judgment. When I look at what is the meaning of service, how the service to be done by the department, service of any notice, order, decree, summon, Section 169 of CGST Act is important. And we are finding divergent judgment. Some of the judgment is saying since order is not uploaded on GST and Common Portal, thereby there is no service of the order. Hence, time limit cannot be calculated unless it is being served to the SAC. Sometimes we are finding only manual copy is being sent by hand, where no acknowledgement is taken by the department. Sometimes we are finding that it is being sent through email, but proper email ID is not being used. Whether it is service or not, we have to be now careful about. If we have registered and given one official email ID, you have to keep track and watch on that particular email which you are receiving, not only your inbox, even in the spam and junk box. Section 169 clearly saying that service of any order, decree, summon and notice can be done through any of the following method: either by courier or by speed post or by registered post with acknowledgement. यानी आपके पास कोरियर के जरिए भी आ सकता है, स्पीड पोस्ट के जरिए भी आ सकता है, रजिस्टर्ड पोस्ट विथ एडी के साथ भी आ सकता है. इसके अलावा they can send you, it is all word use or means alternative method. They can send you on your email ID which is registered as per your registration when you have taken the registration. यानी आपके ईमेल पे भी आ सकता है, और ईमेल पे आप चेक कर लीजिएगा अपना इनबॉक्स एंड जंक बॉक्स जरूर देखिएगा. एंड इट इज रूटीन रिक्वायर्ड टू बी. कल टाइम पीरियड निकल गया, then this Supreme Court judgment I'm damn sure is going to be cited in all future litigation by the department. And on period of limitation we will have no ground to argue. So we have to be very careful about. Even they can upload such notice, order, decree, summon even on GSTN portal. आपकी आईडी जहाँ पे है वहाँ पे वो GSTN कॉमन पोर्टल पे अपलोड करेंगे. तो आपको मालूम होना चाहिए GSTN पोर्टल पे जाके आप कैसे रेगुलरली उसको चेक करेंगे. और they can publish this particular notice or order or decree or summon even in local newspaper by way of advertisement, and this is the alternative method. Or they can affix this notice or order on the premises where you are, when department know that you were known at this place at last time they have recognized you were there at that premises, वहाँ पे वो नोटिस एंड ऑर्डर को अफिक्स कर देंगे. अगर वो भी नहीं हुआ तो जो कंसर्न जुरिडिक्शनल ऑफिसर्स हैं वो अपने नोटिस बोर्ड पे उसको लगा देंगे. एंड दिस इज वन ऑफ द मोड फॉर सर्विस ऑफ द ऑर्डर. सो लुक एट द वाइड implication. Alternative way given in the hands of department to serve any order, notice, decree, summon, etc. We have to be very careful about. So as per this Supreme Court judgment which is upholding Patna High Court, if you have not used the alternative remedy which was available, then quite obvious that writ court can reject and dismiss your writ petition, that you can't invoke extraordinary jurisdiction under Article 226 to the Constitution of India. Having said that, the important line item worth noticing: having alternative remedy does not mean that, and need not necessarily, that I can't go for the writ petition. ऑल्टरनेटिव रेमेडी है तो क्या मैं रिट फाइल नहीं कर सकता रिट कोर्ट में अंडर आर्टिकल 226 एंड 227 to the Constitution of India? Yes, I can do that, provided I can prove before Honorable High Court 4 ground. If there is violation of fundamental right, if violation of principle of natural justice, if there is excessive jurisdiction, beyond jurisdiction, any order or notice is being issued, and last, when you are challenging wires of the legislation law, जब आप law position को challenge कर रहे हैं, having alternative remedy, you can always having right to go for writ petition before Honorable High Court under Article 226 or 227 to the Constitution of India. So alternative remedy is not a bar, provided you can prove these 4 situations before Honorable High Court. But you have to really check whether you have any ground or condition to say that these are being violated. If these are not being violated, then you must use the alternative remedy, and that too within time-bound manner as specified within the GST law. So this Supreme Court judgment is worth noticing, which is upholding the Patna High Court. Hope you have digested all this corresponding provision, and a detailed newsletter is given in the description box, which you can download for your easy digest. Keep tuned. Stay tuned means a number of videos will keep coming from our side. Thanks for watching. Stay tuned. Thank you very much.